Please be seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We continue to be outside the presence of the jury. I had a chance to consider what Dr. Gray testified about a moment ago. First of all, I found his testimony to be credible, and that's based not only on the content of the answers that he provided to the questions asked by the attorneys and me, but also based on my observations here in the courtroom. And that includes all of the factors that the case law tells me to take into account as I assess credibility, especially in relation to witnesses. I also looked at 508 Northwestern 2nd 352. This is the North Dakota Supreme Court case from 1993. There seem to be two areas at issue here in terms of what the prosecution is attempting to do. And before I address those two areas, let me address the copyright concerns. The concerns that we talked about yesterday and I think the day before had to do mostly with the concerns of CMHIP with respect to the trade secrets and the copyrighted materials included in the testing or in the tests that were administered in this case, the MMPI-2 and the PAI. It appears that at least as of this time, Colorado Mental Health Institute of Pueblo, CMHIP, is not overly concerned as long as the questions are not read in their entirety and as long as the attorneys, to the extent that they ask questions, they rephrase the questions. Now that causes some concerns for the defense, and Mr. King expressed concerns about that, but as long as nobody's just reading all the questions verbatim, it appears that CMHIP's concern is alleviated. The question then is with respect to two areas, and that is, number one, whether the prosecution should be allowed to ask questions of Dr. Gray related to the specific questions in the testing materials in order to challenge his conclusions. And number two, whether the people should be allowed to go into the contents of the testing materials, in other words, the questions, for purposes of introducing substantive evidence or evidence of the defendant's statements that may be relevant and admissible in this trial. So let me address those two areas in the order that I mentioned them. First, in terms of going into the questions for purposes of challenging Dr. Gray's conclusions, I agree with Mr. King that there are concerns about misleading the jury and confusing the jury. And I think that given the testimony from Dr. Gray, this appears to be a process that is neither strictly mechanical nor strictly discretionary. It has components of both, and that's not surprising. Dr. Gray takes the answers provided by the defendant, he puts them into a sort of computer or software, and then given some work by the software, he then draws conclusions from them, and then he follows up sometimes with the person being tested. He did in that case, although in this case, the answers provided by the defendant in the follow-up interview did not affect his conclusions. I fear that if the lawyers are allowed to go into the questions for purposes of challenging the test results and the conclusions that were reached by Dr. Gray, that gets into an area that's dangerous, and it gets into an area where I think the jury is then placed in a position of second-guessing Dr. Gray and his scoring of the test, if you will, of each test, and his conclusions based on the test results. and the jury doesn't have the qualifications to do that. I think the proper avenue for the people to do that, and let me just say that I agree with Mr. Brockler, and I said this as well. Neither party should be bound by opinions expressed by an expert. If an expert takes the witness stand and is going to offer expert opinions, both parties are entitled to question that expert about those opinions. It wouldn't be fair for them to be stuck with his opinions and not be able to get at the reason for the opinions, at the rationale for the opinions, at the basis for the opinion. And that's sort of what we're talking about here. But in this case, because these are conclusions that are based in part on work done by some type of computer software, and in addition, some discretion in reading those results based on a certain protocol and based on the witness's expertise, I think it is dangerous to allow the parties to go into some of those questions and pick out some of those questions, especially given the testimony of Dr. Gray, which was elicited by Mr. King, in terms of what's more important is the groups of the questions as opposed to individual questions, and some of the patterns that are recognized in some of the answers that are provided. So although I agree that a party should never be stuck with whatever an expert says, I think in this case the proper way to attack the conclusions reached by Dr. Gray is through an expert witness. And the people have that expert. Apparently they've retained Dr. Rogers. If they want to call Dr. Rogers, they can. I think that's the way to do it. The way to do it, I think, is to have someone else who has expertise in administering the test and in scoring the test to say, I think Dr. Gray made a mistake, or I think Dr. Gray misscored the test or scored it wrong, or I think his conclusions are not supported or substantiated by the test results, and here's why. I think that's the way to do it. Now, Mr. Brockler can still cross-examine Dr. Gray in the way that he spoke about here in general terms, that the procedure that is followed is that there is a test, for example, that's used of so many questions, 567 true-false questions. Some of those questions are odd questions. And then once the answers are provided, then those results are put into some kind of software, and then they're grouped into categories, and then the computer tells you, or the software tells you, which areas are most critical based on what the software reads in terms of the direction of the answers provided, and then conclusions are drawn from those procedures. I think you can go into those in general and say, this is how you went about this, and this is your reading of the test results. I think you can do all that without getting into the specific questions. And I think that would be the way to attack the testimony if the people want to do that, or if the people want to question some of the opinions of Dr. Gray. I think that's the way to do it, but I don't think it would be appropriate to get into just specific questions, to pick out specific questions. Same thing with the PAI. The people can cross-examine in general about why the answers may not, or the conclusions may not be reliable. They can examine in general about what the PAI entails. They can cross-examine in general about how that there is part of this that's from a computer, and there's part of this that is Dr. Gray drawing his own conclusions from it, that kind of thing. But I believe Dr. Gray when he said that if 50 people were reading these answers, all 50 psychologists would probably come to generally the same conclusions. I'm sure that there would, or I think he said 49, because there's always somebody who's odd. And I think that applies in every field. I don't think psychology is the only one that is immune to that. But I think in general, I believe him when he says in general, most, if not almost all, of the psychologists reading these answers would come to similar conclusions, at least similar conclusions. And the proof is in the pudding. The people's own expert, Dr. Rogers, apparently came to the similar conclusions. And I know that people didn't just go out and get Dr. Rogers. I know that Dr. Reed apparently had Dr. Rogers give these answers a second look, and had Dr. Rogers give these answers a second reading. And Dr. Rogers apparently came to similar conclusions. And what that tells me is that this is less about each particular psychologist exercising his or her own discretion in drawing conclusions, and that a lot of this is controlled by the standard test and the software that's used. So, and the testing protocols in place, if you will. And so for that reason, I am not going to allow the people to question Dr. Gray about specific questions in either test for purposes of challenging the conclusions that he drew. And by the way, to allow the people to do that, I think would then require me to allow the defense to introduce the test in their entirety. And that's problematic. Number one, it's problematic in terms of the trade secrets and copyrighted material for purposes of CMHIP's concerns. Number two, and more importantly, it's problematic because there are answers in these tests that the jury should not look at, that I've already ruled are not areas that are appropriate to introduce any evidence on during the guilt phase of the trial. So that would be very problematic. So that's one area. The second area then is an area that Mr. Brockler brought up today, and he said, Judge, there's no reason to prevent us from introducing some of the statements that the defendant made during the test. And some of the examples he gave were, and I didn't have a chance to look through the test. I quickly browsed through them, but I didn't have a chance to review every question. In fact, I haven't read most of the questions in these tests. I wanted to get going on this. But one of the questions that was mentioned had to do with evil spirits possessing the defendant at times, and the defendant denying that. The defendant apparently was asked the question about whether evil spirits possess him at times, and I believe, according to what Mr. Brockler said, the answer was false. Another question had to do with visual hallucinations, and I don't know what exactly the question was, but Mr. Brockler referred to visual hallucinations. Another had to do with audio hallucinations. Another one had to do with his demeanor. Another one had to do with his mood, and another one had to do with social interactions. And then there was one about hopelessness that he mentioned. And this gets trickier and more difficult because I agree with Mr. Brockler, but I can't think of any reason why a defendant's statements, so long as they're relevant and admissible, would be rendered inadmissible simply because they were made as part of this examination that was conducted by Dr. Gray. For example, and I have no idea what the question is, but let's say, for example, that the defendant was asked if he had ever experienced visual hallucinations, and he said no. How is that not relevant and admissible in this trial? Or let's say that the defendant was asked about his own demeanor, and let's say he said that he was outgoing. How would that statement not be admissible? I haven't been given any reasons why it would not be. Certainly, it would go to the heart of the case. It would go to the claims that have been advanced by both parties, and it would be extremely relevant under Rule 401 and admissible under Rule 403 because the probative value of the evidence, at least in the examples, would not be substantially outweighed by the danger for unfair prejudice or any of the other concerns in Rule 403. So I think in terms of those types of statements, I agree with Mr. Brockler that they're admissible, but here's the thing, a caveat. If Mr. Brockler decides to go into some of these statements, I think in order to be fair, I'm going to have to allow the defense to go into other statements that may be favorable to them. And I would not view them as hearsay, even though they may be self-serving, because I would treat them as part of an interview. It would be like when you're being interviewed by a police detective. During a police detective interview, you would not just take the answers that are helpful to the people and allow those because they're admissions by a party opponent, and then exclude other statements. You admit the entire interview. Similarly, in the interview by Dr. Reed, I admitted the entire interview. I didn't just admit the things that the people thought were favorable to them. I admitted things that were favorable to Mr. Holmes as well. So the second caveat is that you're going to have to be careful not to violate my first ruling. So my first ruling in terms of not getting into the questions to challenge the conclusions that were drawn. So if what you're intending to introduce is the statements that the defendant may have made, I think the way to do it would be to just refer to the statements. And to be fair, I think you have to frame, to put the question that elicited the statement in context. So for example, the defendant indicated to you in response to a true-false question that he's not possessed or that evil spirits do not possess him at times, or something along those lines. It has to be fair, so I think you have to be fair in how you ask the question and how the jury hears about the statement. The hopelessness question gives me concern because it sounds like one of the conclusions that Dr. Gray reached and that he's going to talk about is that the defendant is hopeless about the future. And so if he's testifying about that conclusion, and it sounds like he will, then to have Mr. Brockler say, well, the defendant said to you in response to a question that he is not hopeless about the future. Now I think you're getting into the area where even if that's not the intent, I think it's going exactly at the conclusion reached, and it's contradicting that conclusion. And I fear that the jury can then infer from that they can ignore the conclusion and just rely on that one answer instead. And that's what I don't want. So if it's a question that goes specifically to one of the conclusions that Dr. Gray reached and he's going to testify about, then I think that's going to be problematic. I think that the best way to handle it is after Dr. Gray testifies on direct examination, if you want to get into some of those answers, I think the best way to do it is to do it outside the presence of the jury first, Mr. Brockler, so we can talk about him, and then I can decide, we can talk, see what objections there are, and then we can go from there. But I think we're going to have to be really, really careful. I get the sense that you're only interested in a handful of statements, and maybe I'm wrong about that, but that was the sense I got from your comments. Is my sense correct?
560? Okay. No, I'm kidding. It's maybe 20, 25 at most.
Okay, so it's more than what I thought. All right. Well, I think the way we do it is you ask to approach before you ask them, and actually what I'll do is I'll send the jury out and then we'll talk, and I want to hear from the defense about each one, and if there's anything that causes me concern, then I may not allow them. But my ruling is that in general, I don't think it's appropriate to get into the questions of the testing for purposes of challenging the conclusions that Dr. Gray reached, because I think that would be confusing and misleading to the jury. But I think that people are entitled to introduce statements that the defendant made without getting into what question was asked or what test it was for or what part of the, which specific examination it was made in response to. Just the statements, and then we go from there. But like I said, the defense will also be entitled to then introduce statements that are favorable to the defendant. So, is there anything else that I have not addressed with respect to this specific issue? Mr. Brockler?
Your Honor, thank you.
All right, Mr. King?
Your Honor, I understand and accept the court's decision. It does somewhat change the playing field. And so with that in mind, I'm going to pass Dr. Gray's testimony at least till later today. I think in all fairness, I'm requesting that the court order Mr. Brockler to let me know in the interim what questions he's specifically intending to go into so that I can decide what I want to do and decide how I want to proceed and decide if I need to object to those or not.
Mr. Brockler?
Your Honor, I object to that for a couple of reasons. One, I don't yet know in its entirety what Dr. Gray's testimony is going to be and what questions I'm going to seek to want to get in through him based on that testimony. And two, I think that the procedure that the court has suggested is one that provides the relevant notice to Mr. King and the defense, and that is the jury's excused. I'll go through the list then, and Mr. King can make some decisions then. But to do it before Dr. Gray testifies doesn't seem to be warranted.
Yeah, and I think the notice that Mr. King seeks is in the test results. I mean, he has the test results. Now, I will work with you, Mr. King, in terms of delaying calling Dr. Gray until you have more time to review the test results. But you know what the questions that were asked are and what the answers that were given were. And you're a smart attorney, you're an experienced attorney, you have experienced and smart colleagues, and I'm sure you can figure out which questions, or excuse me, which statements the prosecution is likely to be interested in. And I don't think there's anything unfair about just letting you review the testing materials, the answers the defendant gave on your own. I will give you more time if you need it. I will allow you a longer recess if we have to take a longer recess. We're ahead of schedule, so if we have to take some time, I'll let you have some time. I'll let you talk to Dr. Gray further if you wish. I'll work with you, but I don't think that the request to have the people state in advance what statements they would seek to introduce is an appropriate one, or one that's necessary. Now, in terms of, you're going to have notice at some point, but I think it will be after the direct examination, and then we'll go from there.
Well, Judge, the only problem with that is, quite frankly, I need to make some larger decisions about the scope of the examination or whether there'll be an examination. And I can't make those decisions unless I know what questions Mr. Brockler is going to go into. And so I can't wait until halfway through the examination to make those decisions. It'll be too late. I'm not asking to litigate these issues prior to the testimony or the direct examination. Mr. Brockler can listen to the examination, and if there's one or two additional questions he wants to add, that is acceptable. And I have no quibble with the court's procedure as you suggested. But I think, in all fairness, for me to be able to make these decisions as an attorney, I need to know just which questions, just the number. You know, I mean, if it's question 5, 6, 8, 9, 25, and 60, that's all I need to know. That's my request.
Mr. Brockler, Mr. King has persuaded me. I'm going to ask you to do that, and I'll give you some time if you need some time, but there are over 1,000 questions that we're dealing with here in 2 different tests. And so I'll ask you to make a good faith list of the statements that you're likely to want to introduce on cross-examination, and then we'll go from there. I'm not going to have you bound by that list. If you want to change it after the direct examination, based on the direct examination, I'll let you do that. But I think it's fair to allow Mr. King to make that decision, to have that in mind, given that there are over 1,000 questions, and given that I just issued my ruling here right now in court. All right, are the parties ready for the jury? Mr. Brockler?
One clarification, Your Honor. Would I then be entitled to know what additional questions Mr. King might seek in response to those so that we could prepare any potential, I guess, argument why those shouldn't come in?
What? Tell me that again. I'm sorry, I didn't follow that.
Suggested, Your Honor, and I think this is appropriate, that if we're able to get into some of the questions and answers, that Mr. King then would be able to pick and choose some questions and answers from that same test that he then would like to have the jury to consider in light of what we did in cross. It makes sense to me. My question is, once I turn this list over to Mr. King, would I then be entitled to his list of responsive questions that he seeks to get in, so we have that kind of argument right then and there too?
All right, Mr. King, any objection to that?
No, Judge, as long as I have time to do it.
Yep.
You said you'd entertain a recess. Could we have, like, till August 1st, perhaps?
No, I'll give you a short recess, but we can take a longer lunch if you like. And what I'm going to order is that you two talk, have you conferred, you're in a long break, and then you can exchange your thoughts in terms of what type of statements each one of you is seeking to introduce, and then we'll go from there. And then you can make whatever decisions you need to make.
We do have some 6 hours of videotape published to this jury, so it's possible I may pass the witness's testimony till the 1st of next week to give some time to do that.
That's great.
If I can think about that.
Yeah, and during the 6 hours, if you wish, you can step out of the courtroom and have conversations not only with Mr. Brockler, but with Dr. Gray, with your colleagues, as long as there's at least one person here in the courtroom while the video is playing. I'm not telling you that you should do it this way. I'm just saying you'll have my permission if you want to do that. If you want to step out for part of the video while it's playing, I'll let you do that. Okay? All right, thank you. Okay, let's bring the jury in, please. Thank you. Mr. Brockler, do you want to retrieve the copies of the MMPI and the PAI?
Yes, sir. Thank you.
Thank you. Detective, thank you for coming back. Please be seated. The record should reflect that the jury is now in the courtroom. Good morning, everyone. It's still morning. If you feel particularly well rested, it's not because we're starting a little late. It's because you had an extra second yesterday at about 6 o'clock. So thank you for your patience. I appreciate your patience again. As I've mentioned before, please don't infer anything from some of the discussions that we have to have outside your presence. Don't hold it against either side. These are things that we have to do outside your presence. Sometimes it's about legal issues. Sometimes it's about administrative issues. Sometimes it's about scheduling. And sometimes it's about all three. And the parties are doing their job. This is what they're supposed to do. So if you need to hold it against anyone, hold it against me. Don't hold it against them, okay? All right, thank you. As you know, yesterday at the end of the day, we had Detective Madonna on the witness stand, and Mr. Edson, I think, was getting ready to start his cross-examination. And so, Detective, I remind you that you're still under oath, and then, Mr. Edson, you may proceed with your cross-examination.
Thank you, Your Honor. Your Honor, can I retrieve some exhibits, please?
You can.
Good morning, Detective.
Good morning.
When you testified a few weeks back, you were qualified as an expert in the area of digital forensic examinations. Is that correct?
Yes.
I want to talk to you about a few subjects here that were brought up on direct examination. The first is related to the iPhone. We're going to be placing on the screen DTR85. This was an exhibit that was introduced yesterday. We can just kind of scroll in to the top there is fine, actually. So this is Defense Exhibit TR85. The first thing I want to talk about is, you see where it says contacts?
Yes.
At the bottom of what's being published here. Ahead of that is actually appears to be some text messages. Is that fair to say?
Yes.
My question is related to this. Just for example, that first one that's dated March 26, 2012, and then has a time of 5:48:48. Do you see where I'm referring to?
Yes.
It has the UTC right behind that. Do you see what I'm referring to?
Yes, I do.
So that's going to
Sir Edson, I think you said March 26th?
April 26. My apologies, Your Honor. UTC. I want you to again explain, what are we talking about UTC? What does that mean?
UTC is Coordinated Universal Time, which is the same thing as Greenwich Mean Time, Zulu time for military and so forth. It's the point on the Earth where it's a zero offset
So
times.
just for jury purposes, if they were to read this particular text and the time is 5:48:48 p.m. and then it has UTC plus 0, what does that mean?
That means for our particular area, where this phone came from, you would have to subtract, depending on the time of the year, it would be minus 6 hours or minus 7 hours, whether you're in daylight saving time or not.
And again, this is a text message associated with the defendant's iPhone, is that correct?
That's correct.
Now, the iPhone itself, depending on what function is, can have times in UTC and other times may not have times in UTC, is that correct?
That is correct.
Okay, we can take that down, thank you. Your Honor, may I approach the witness, please?
You may.
I've handed you what's been previously introduced, through you actually, People's Exhibit 425, and a particular page that has some metadata associated with that. Do you see that?
Yes, I do.
If we could please have on the screen 42526. Now, you testified previously about metadata associated with this particular photograph. Do you recall doing that?
Yes, I did.
My question is related to the time associated with this and whether it is in UTC or not UTC.
This would be local time.
Okay, so for jury purposes, what time is the relevant? Because I see a created time and I see a captured time.
Okay. You want to refer to what the metadata says. This is directly from the camera on the iPhone itself when that picture was taken.
And so on this particular Exhibit 425 and this particular photograph, which again, the jury has seen this photograph, this is the various items laid out on the bed, what was the capture time?
At 5:17:40 p.m.
And is that local Denver time?
Yes.
And so there's no addition or subtraction necessary for that time, correct?
Correct.
All right, thank you. You can take that down. Is that the same information related to all of the captured times for the images in the iPhone?
For the pictures that were taken with that phone, yes.
So in other words, the pictures do not require any sort of addition or subtraction for UTC, but the text messages we just showed you may. Is that correct?
Correct.
All right. May I again approach the witness, Your Honor?
You may.
Thank you. I've handed you what has been previously introduced and we talked about yesterday on direct, People's Exhibit 424A. I also have 424B, which is in front of you. 424A, I believe, are the actual screenshot images. Is that correct?
Yes.
And then 424B is the Excel spreadsheet that correlates with those screenshots. Is that correct?
That is the session store artifacts, yes.
Okay.
Those are the Firefox session store artifacts.
Now, you were showed yesterday several Bing website searches. Do you recall that?
Yes.
Many of them had to do with philosophical terms. Do you recall that?
Yes.
Fair to say there were not just philosophical Bing searches associated with these screenshots. Is that correct?
Correct.
If we could please have 4241. Here we're looking at, just like yesterday, a Bing web search. However, this one is related to target shooting, correct?
Yes.
(42416). Another Bing search, this one relating to window tint fine, Colorado or CO, correct?
Yes.
42419. A Bing search related to Century 16 or Century Aurora 16, correct?
Yes.
42425. A Bing search related to firing systems for fireworks, correct?
Yes.
42433. A Bing search for firing systems, correct?
Yes.
Now, again, as kind of recollection here, these are all searches that came from the eCyberPower Tower PC, correct?
Yes.
So this is one that we cannot give a particular date associated when this search happened. We can give a date range of April 26, 2012 until July 19, 2012. Is that correct?
Yes.
42439, 39. Here the search was for a 1/8 fuse, is that correct?
Yes.
And actually, even below that, the first thing that comes up relates to cannon fuse, correct?
Correct.
42444. This Bing search related to a launch control transmitter, correct?
Yes.
42446. This was a launch control problem, correct?
Yes.
42449. This is a Bing search related not to philosophical terms, but instead to potassium permanganate and gasoline, correct?
Yes.
We could have 42458, please. You talked yesterday about some images, or searches, I should say, related to Wikipedia. Do you recall that?
Yes.
Here's a Wikipedia search related to weapon. Is that correct?
Yes.
42459. A Wikipedia search related to military tactics.
Judge, I'm going to object to the characterization as a Wikipedia search. It's a Wikipedia entry.
Distinct.
Is that correct, sir?
Yes.
A Wikipedia entry of military tactics. Your Honor, may I approach the witness, please?
You may.
I've given you exhibit admitted yesterday, DTR 86. Do you recall this exhibit?
Yes, I do.
You were asked some questions yesterday about the second page of that exhibit, and if that is how that particular website relating to the search for related to depression, if that's how it is today. Do you recall those questions yesterday?
Yes, I do.
Can you say for sure that that is in fact how the website would have appeared back during that time period of April 2012 to July 2012?
No, I cannot.
Please explain to the jury.
Well, as I mentioned yesterday, when we did the other screenshots, those are within several days of the incident and so forth, so those were close, but even at that point in time, we couldn't guarantee that it was exactly the same way that the user would have seen it when they accessed that website on that date and time. This one was approximately, 3 years later, so I can't say that it was the same or if it was different. I do not know.
You were asked questions yesterday about the eCyberPower tower that you did the extraction on, correct?
Yes.
You were also asked questions about the Lenovo tower PC that you performed extraction on, correct?
Yes.
Did you also perform extraction on a Toshiba laptop PC?
Yes.
And that Toshiba laptop PC, do you recall what the account was named or the primary user associated with that particular computer was?
I would have to look at my report.
Would that refresh your memory?
Yes, it would.
Your Honor, may I approach the witness, please?
May.
For counsel, I'm looking at page 7 of his report.
Okay.
Do you
The
recall,
name,
I'm sorry, let me re-ask the question. Do you recall the username with that Toshiba computer?
yes, I do.
And who is that?
James?
Was there, and if you have that report in front of you, let me know if you need to refer to that, but do you recall what the last login date for that Toshiba computer would have been?
May 17th, 2012.
Okay. And may I approach to retrieve my report?
Yes.
Thank you.
It's not your report, it's your copy of his report.
Only a small portion.
The court is absolutely correct. When you performed the extraction associated with the Toshiba laptop PC, did you also obtain some various web search information from that particular computer?
Yes.
Explain to the jury how you did that and what you obtained.
As I mentioned previously, we have special tools for depending on what we're doing and so forth. In this particular case, we used Internet Evidence Finder, which specifically goes out and looks for web history. In this particular case, I believe it was Firefox, and it will carve out those artifacts and create a report for us.
What does that information look like when it's in a report form?
We provide it in what's called an HTML format, which is basically, it looks like a computer screen format so that you can click on the links and it will take you to the various aspects of the report. If you looked at all the reports that we did on the findings, DVD and so forth, you'd probably be looking at about 60,000 printed pages. So it makes it a lot easier to present.
And even if you break that down into an easier presentable format, fair to say that's several hundreds, if not 1,000 pages of various web search, is that correct?
That's correct.
Nonetheless, despite the volume of this, did you have an opportunity even before yesterday to review some of the web searches associated with that particular extraction of that Toshiba satellite computer?
Yes.
Is it correct that on January 26, 2012, there was a Wikipedia search on that Toshiba computer for mental disorder?
Without seeing the report, I couldn't tell you.
Would it refresh your memory to take a look at some selected pages from that list of web searches from that Toshiba?
Yes.
Your Honor, may I approach the witness, please?
Yes.
I can see.
Won't be all of these, but I'm just doing page 883 through 889. I can give you that copy. Okay. Okay. I'll just give you this copy. Okay, thank you.
And Judge, for the record, I will show the detective page 883 through page 889 of his extraction of the web searches associated with the Toshiba laptop. I've given a copy of those pages to the defense as well.
All right.
So my question is it correct that on January 26, 2012, the user of the Toshiba laptop entered a Wikipedia search for mental disorder?
Yes.
Is it also true that on January 26, 2012, the user of the Toshiba computer entered a Bing.com search related to mental disorders?
Yes.
Also on January 26, 2012, the user of the Toshiba laptop entered a Wikipedia search related to delirium.
That's correct.
Judge, I'm going to object to the characterization as search. It's a Wikipedia entry again.
All right, sustained. Rephrase the question, please.
Is it correct that on January 26, 2012, the user of the Toshiba laptop entered a Wikipedia entry for delirium?
Yes.
I'll direct your attention to page 887 of the Toshiba web searches. Is it correct that on January 26, 2012, the user of the Toshiba laptop had a Bing.com entry for psychopathic,
Yes.
as well as psychopathy,
Yes.
as well as demented?
Yes.
as well as hallucinate.
Yes.
Draw your attention to page 888 of your report, of that particular web search report.
Would counsel approach for just a moment, please? Mr. Edson, you may proceed.
Thank you. Believe I was directing you to page 888 of that report. Do you see that page?
Yes, I do.
Isn't it correct that on January 26, 2012, the user of that Toshiba laptop had a Wikipedia entry for hallucination?
Yes.
As well as Wikipedia entries for psychosis and delusion,
Yes.
as well as insanity.
Yes.
Isn't it correct that also on January 26, 2012, the user of the Toshiba laptop had Bing searches for insanity,
Yes.
as well as delusions of grandeur?
Yes.
I'll direct your attention to the next page, 889 of that report. Isn't it true also on January 26, 2012, the user of the Toshiba laptop had a Wikipedia entry for grandiose delusions,
Yes.
as well as megalomania?
Yes.
Can I have one moment, please?
Yes.
I have no further questions at this time, Your Honor. Thank you.
All right, thank you. Redirect, Ms.
Yes, sir.
Spangler.
Related to the searches and entries that you just testified about, Detective, that came out of the laptop from the Firefox carved history, is that right?
Yes.
Okay. And the report that you talked about earlier that generates the data related to the internet activity or entries within a computer, that's digital and you provide that to both of the parties, is that right?
Yes.
Okay. I am going to approach with what I am marking as Defendant's Exhibit 89. I'll put the sticker on the back because there's data on all the pages. And I'm not going to move for its admission right now, but I'll show the district attorney.
Okay.
I may approach.
Yes.
Now, Detective, what I've handed you is data similar to what the district attorney handed you, but it's in a different format. But that format does connect to your report. We can see that it reflects the Aurora Police Department internal case number, as well as the Toshiba laptop, as well as the internal evidence item number down on the file path. Is that right?
That's correct.
Okay. And at the top of this report, we see that this is coming out of the Firefox carved web history. So I want to just talk to you about the dates and times of this activity. You mentioned that these searches and entries were on January 26th. Now, the time would need to be converted. Is that right?
Yes.
Okay. And so to convert the time on these searches and entries, because it's January 26th and not daylight savings time, we would subtract 7 from those 1900 hours. Is that right?
That is correct.
Okay. So all of those searches and entries occur within 1900 hours, which would be about 7 p.m. Is that right?
That sounds about right, yes.
Okay. And then if we subtract 7, we'd get to Colorado time at about 12 o'clock p.m.
Yes.
Okay. So now I want to talk to you specifically about the timing of these searches or entries. And I want to talk to you about that in relation to an exhibit that's already been admitted by the prosecution. And I'd like to publish that exhibit now. It's People's 22.
Okay.
And that would be... (3177). All right. So, Detective, you can, what I'm going to do is I'm going to ask you some questions about the specific times of some of these entries and searches that you've testified about, and whether you use the data that I provided to you or the prosecution's data, that's fine. But what I'd like to do is to refer to what's been published, and what this is a chat between Mr. Ben Garcia, who's testified, and a D. Sherlock B., Mr. James Holmes. And this took place on January 26th. And you see that the conversation began about 11:33 a.m. on the morning of January 26th. Is that right?
That's the time noted, yes.
Okay. And so if we go to page 2, please, and if we call out the entries starting at 12:08, between 12:08 and 12:16. So this is a text message between Mr. Garcia and Mr. Holmes, and again, the jury's already seen this, but this is January 26th, and now we're talking about 12:08 p.m., which is consistent with the times of some of the searches. So I want to just draw everyone's attention to the entry at 12:10, where Ben Garcia references, if the murderer is psychopathic, it does. And then what time is that psychopathic term entry that you testified about earlier? Out of the computer data.
I don't recall what that entry was.
Okay. With looking at either the exhibits help.
There was two, psychopathy or psychopathic?
Well, there's a Bing search for psychopathic at 12:11 p.m. Is that right?
It would be 1911, so minus 7 hours, so yes.
Okay. And at 12:11 p.m. is when we go to that Wikipedia entry for psychopathy, correct?
Correct.
Now, at 12:13, we see in this exchange, well, at 12:12, Mr. Garcia writes, "Not if it is fueling your murderous rage," and then 12:13 from D. Sherlock B., "Then I have a reasonable explanation for my demented actions towards you." 12:14, "Don't think demented is the correct term," is how Ben Garcia responds. And what time are those demented searches that you testified about earlier?
That would be at 12:14, 12:15.
And if we can call out the second part of the page from 12:16 to the end of the page. You mentioned a hallucination or hallucinate search, again referring to the same chat on January 26th between Mr. Garcia and Mr. Holmes. Mr. Holmes writes, "Pretty sure I'm a psychotic being," and Ben Garcia asks, "You hallucinate often or are you demented?" And what time is that hallucinate search?
That'd be at 12:18.
Okay, and that's also reflected in the comment from Mr. Garcia about whether or not Mr. Holmes hallucinates.
Appears to be, yes.
Okay. And then if we look at those entries for insanity and psychosis and delusion, Mr. Garcia at 12:19 asks, "What kinds do you have?" And Mr. Holmes at 12:21 responds, "Psychotic delusions," but at 12:20, do all three of those, the insanity search, psychosis entry, and delusion entry take place?
Psychosis at 12:20, delusion at 12:20, and then delusions of grandeur at 12:25.
Okay, but do you see the psychosis? That's also 12:20 within that same minute?
Yes.
Okay. And then if we go to page 3 of this exhibit and call out 12:24, please, through 12:29. Mr. Garcia at 12:24 asks Mr. Holmes, "Do you have delusions of grandeur?" And what time is that delusion of grandeur term search?
That was at 12:25.
Okay. And the I think that covers it. If I may have a moment.
You may.
Thank you. I have nothing further.
Is there any recross?
No, thank you, Judge.
All right, and the jury does not appear to have any questions for Detective Madonna. May Detective Madonna be released from his subpoena, Ms. Spengler?
Yes, Your Honor.
Is there any objection, Mr. Edson?
There's no objection.
Detective, thank you. Thank you for coming back today. Call your next witness, please.
Dr. Rhodes, may I do so?
Good morning, Doctor.
Good morning, Your Honor.
Could I have you raise your right hand, please? Do you solemnly swear or affirm, under penalty of law, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated. Doctor, please tell us your full name and spell your first, middle, and last names.
My name is Rose Marie Manguso. That is Rose Marie Manguso.
Mr. King, you may proceed with your direct examination.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
How are you?
Fine, thank you, Mr. King.
Good. What do you do for a living, ma'am?
I am a neuropsychologist at the Colorado Mental Health Institute at Pueblo.
And can you please talk to us a little bit about your education, if you would? Where did you go to college and what was your degree in?
I went to college at the College of St. Catherine in St. Paul, Minnesota. I majored in psychology and speech communication, earning my Bachelor of Arts degree in 1984.
What is a neuropsychologist, anyways?
A neuropsychologist is a psychologist who specializes in studying the behavioral manifestations of brain disorder.
Okay. And what do you have to do, other than, I'm assuming you have to have a bachelor's degree to begin with, what else do you have to do to become a neuropsychologist?
You have to earn a doctorate, PhD, or another doctorate degree in psychology, and then go on to complete postdoctoral training,
Okay.
and typically board certification after that.
Did you, where did you complete your PhD?
The University of Maryland in 1989.
How long did that take?
5 years.
And following that, did you have a postdoctoral training in the area of neuropsychology?
I did. I completed a postdoctoral fellowship in clinical neuropsychology at the University of Wisconsin Medical School Department of Neurology from 1989 to 1991.
And in 1991, did you begin your work as a neuropsychologist?
Yes, I moved to Colorado and accepted a job at a brain injury rehabilitation facility in Aurora, actually.
And how long were you there?
Was there until 1996.
And what was the nature of your work there?
I worked as a neuropsychologist and behavioral health specialist as well before I became licensed, conducting neuropsychological testing of the sort I did in this case. And I also had more direct patient care duties surrounding the behavioral plans for these brain-injured individuals.
Okay. In 1992, did you move on to the Spaulding Rehabilitation Hospital in Aurora?
Well, in 1992, I became licensed, so I became a licensed psychologist in Colorado. I stayed at the same facility. It simply changed in names from Rocky Mountain Rehab Institute to Spaulding Rehabilitation Hospital.
Gotcha. I didn't know that. What does that licensure procedure look like, and what does it involve that you have to go through to become licensed?
I had to pass written and oral examinations to practice psychology in Colorado.
Is that important? I guess it's important if you want to practice psychology, huh?
It's important in order to practice independently in any state to have a license.
And have you remained licensed since that time?
I have.
1992. Did your responsibilities change when the name changed, or
No,
not?
just that a different company owned the hospital. My duties were fairly similar.
Okay. And when did you begin your work at the Colorado Mental Institute in Pueblo? Were you initially on staff there, or did you do some contract work? How did that play out?
Yeah, in 2001 I began contract work there, and then in 2002 I joined the permanent staff.
And have you done any private practice work, or has your work always been associated directly with the hospital? And I mean your work since you moved on from the Spaulding Rehabilitation Hospital.
Yes, I worked in private practice for several years in conjunction with working part-time at the hospital from 2002 to 2006.
What kind of work was that private practice as a neuropsychologist?
Yes, and of course by this point I had, just parenthetically, I'd become board certified, of course, and so I received many referrals from insurance companies, attorneys. They were typically questions of traumatic brain injury and related disorders.
Okay, and I want to talk a little bit more about what you actually do, your hands-on work as a neuropsychologist, but you just mentioned that you became board certified during this period of time. What year did you become board certified?
In 1995, I became board certified in clinical neuropsychology, and in 2009, I became board certified in forensic psychology.
Okay. What's the difference between licensure and board certification?
Well, licensure enables a psychologist to practice independently within the scope of their education and training. Board certification is an additional credential where one is examined by a national panel and determined to have specific and higher-level competencies in any number of specialties.
Are you required to be board certified in a certain specific area to practice neuropsychology in that area?
One isn't required, but it's generally preferred.
Preferred, so it's something you can say, look, I've gone through this additional, I've leaped over this additional hurdle, if you will. I'm even more qualified than I was before. Is that fair to say?
It's fair to say. I've been examined by a jury of my peers and found to have specialized competency.
Okay. And you said that you were first licensed in clinical neuropsychology, and then you were later licensed in forensic, was it neuropsychology or just psychology?
Well, just a clarifying point, so I was board certified in clinical neuropsychology.
Oh, I said licensed, I'm sorry.
That's okay. And then later board certified in forensic psychology.
Okay. And why the board certification in forensic psychology as opposed to neuropsychology?
Well, I wanted the additional forensic psychology credential because by this point I was working at the state hospital, Colorado Mental Health Institute at Pueblo, with many, many criminal forensic defendants, and I thought it important that I obtain the additional education and then demonstrate my competency to conduct evaluations in that realm.
Now, is neuropsychology a kind of a specialty of psychology?
Yes.
Can you then administer all the psychological instruments that any other psychologist could administer, for example?
As long as I'm trained to do so, yes.
Okay. Does your training, specialized training in neuropsychology, enable you to administer other instruments for other purposes as well?
My training as a psychologist enables me to administer, again, any psychological test that I have been trained and am able to do. My credential as a neuropsychologist would enable me to administer any number of neuropsychological tests. And many times straight psychological tests will accompany a neuropsychological evaluation.
So, and I guess perhaps I'm being unclear, but my point is you're able to do all of that, but you have a specific specialty in neuropsychology. Is that fair?
That's fair.
Now, in terms of the neuropsychological instruments that you administer, you have this board certification in forensic psychology. Does that mean that you administer those tests differently? For example, if you're at the state mental hospital dealing with a criminal matter or dealing with a non-criminal matter, are the tests different?
The tests are the same tests, and then the question being asked of the psychologist may be different depending on the context, a criminal forensic case versus a disability claim, that sort of thing.
Can you give us an example of what how the questions might be different in that context?
Sure. For example, in this case, I was asked to administer neuropsychological tests in the context of an examination of the defendant's sanity that was being conducted by a psychiatrist. So I had a role that was specifically focused on neuropsychological testing to provide information to the psychiatrist to assist in making that call. I also, in a different context, for example, in private practice, I might have had a case referred by an insurance company to determine whether someone had deficits from a traumatic brain injury that the insurance company would or would not reimburse.
So suffice it to say you use the same test to answer different questions in different contexts.
That's correct.
Now, have you presented or taught any of these on any issues that relate to psychology or neuropsychology over the course of your career?
I have. My job at the state hospital requires me to present on occasion educational seminars to younger colleagues and other colleagues. And then in addition to that, I have presented at professional conferences in my area of expertise.
And have you published articles or books or other
No, I've devoted,
publications?
I'm sorry, I didn't mean to cut you off. I've devoted myself to clinical work, so no, I haven't published since many, many years ago. When I was in graduate school, I had research publications that were in other areas. But as a practicing neuropsychologist, I have devoted my days to clinical work primarily, so no.
And can you explain that to us? Do some folks focus more on research in the area of neuropsychology, and some focus more on clinical work, and some split the two?
I think that's fair to say. Some primarily do research and just a little bit of clinical work. Others, like myself, primarily do clinical work and occasionally give professional presentations. And then there are others, for example, who might be affiliated with an academic institution who do both pretty even-handedly.
Okay. Are the publications that you've made and the presentations that you've given, as well as your education and certifications and licensure, all contained in your curricula vitae?
Yes.
I'd like to, what defense exhibit are we up to? 9-0? If I may approach the witness, Your Honor.
You may.
I'm handing a copy to counsel. Ma'am, I'm handing you, my goodness, what I've marked as DTR 90. Can you identify what that document is for me, please?
It is a copy of my Vita.
And is that an accurate copy of your current Vita that we were provided, I think, just a couple days ago by you?
Yes, it is the updated copy of my Vita.
Judge, I'd move the admission of DTR 90.
No objection.
All right, without objection, it is admitted.
You could just leave that up there somewhere, that's fine. Excuse me. I want to talk to you just really briefly about your work at the Colorado Mental Institute at Pueblo. What do you do there, since you've, both when you were on contract and since you've been on staff?
When I was on contract, it was under two different conditions. The first time, I mostly did competency to proceed evaluations, and my second period as a contract worker, I did neuropsychological evaluations.
Okay.
When I first came on as permanent staff, again, I worked part-time there from 2002 to 2006. And I did both neuropsychological evaluations and competency to proceed evaluations. That proportion of duties remained the same when I became full-time staff, and I continued in what became the Court Services Department, doing many competency to proceed evals, and then neuropsych evals as well. And then my job changed in last June.
Okay. And I guess how did it change?
I joined the psychology department as the hospital's primary neuropsychologist.
Okay. A promotion, it sounds like.
Well, it was a lateral transfer, to be perfectly specific, but it was a welcome change. It was a good change.
In the context of your work at the Colorado Institute at Pueblo, let me just use Mr. Holmes as an example. In this case, Mr. Holmes, you're aware, was being held at the Arapahoe County Detention Facility. Is that right?
That's right.
He wasn't committed to your hospital, was he?
Not before his evaluation, no.
Okay. He was brought there for the evaluation.
That's correct. That would be the correct term.
And then brought back to the jail. Is that fair?
Fair.
So do you do these neuropsychological evaluations both on individuals like Mr. Holmes that may be in jail and individuals who are actually committed and reside at the Colorado Mental Institute at Pueblo?
Yes, I do both types.
Okay. Are there people that are there long-term due to their commitment either criminally or civilly?
Yes, there are some people who are there for many years.
Now, in the course of your work, over the course of your career, how many times do you think you've conducted a neuropsychological evaluation or administered those instruments?
Approximately 500 times.
Okay. And have you testified in court like you are today about the results of your testing and your conclusions?
I have.
How many times do you think you've done that?
I've testified in court on 41 occasions, and not all of those were neuropsychology. related questions, but 41 occasions, 40 times in Colorado District Court and once in federal court.
Okay. And on each one of those occasions, were you qualified by the sitting judge as an expert in neuropsychology?
In various cases, I was qualified as an expert in forensic psychology. On many of those cases, I was qualified as an expert in neuropsychology. It depended on the case.
Okay. Have you ever, has any judge ever said, no, I won't qualify you as an expert?
No, that's never happened to me.
Judge, I'd move the qualification of Dr. Mancuso as an expert in the fields of clinical neuropsychology and clinical forensic psychology under Rule 702 and People versus Schreck.
Any objection?
Here, Your Honor.
Yes.
Good morning.
Good morning, Mr. Proctor.
A couple questions. You were asked about the number of times you've been qualified as an expert and testified. Can you give us some sense, in terms of when you've been called to testify, has it been both prosecution and defense?
Yes, I've testified for both the prosecution and the defense.
And let me ask you a little bit about this forensic psychology board certification. Is that something where you just send in an application and say, I'd like to be it, and they just give it to you?
No, you have...
Tell us about it.
Sure. So to become board certified in forensic psychology, of course, you have to be licensed, and typically for 5 years, which was well past that for me. I'm 53 at this time.
I did not want you to have to testify to that. No, I'm kidding. I'm joking. You're never supposed to ask that question. So
That's all right. I don't mind answering. So I had to be in practice for a certain number of years, and then I had to complete a certain number of hours of continuing education in forensic psychology. I believe that was 100 hours. And then I had to submit my credentials to an examining panel, which made sure that indeed I was qualified by my training, education, and licensure. And then I had to, after I was approved for that, I had to sit for a written examination, which was like a multiple choice examination regarding my knowledge of forensic psychology per se. It's, strictly multiple choice. After I passed that, I had to submit 2 work samples in different areas of forensic psychology practice, and then those were reviewed and determined if my writing and my report were adequate to proceed to the oral examination. And then I had to go to Cleveland and take an oral examination in forensic psychology, where I was questioned by a panel of 3 board-certified forensic psychologists regarding my reports and my knowledge of the literature and the case law in those areas.
that sounds kind of rigorous.
Yes, it was.
In fact, it's not just a checkbox thing, I've done this many times. It sounds like other experts in the forensic psychology field get a chance to kind of turn you over and ask a lot of detailed questions and poke and prod before they bless off on you with having that particular certification. Is that fair?
I like that description, and yes, that is what has to happen, basically.
Your Honor, in addition to cooperating in that description, I would have no objection to this witness testifying, being qualified as an expert in the area of clinical neuropsychology and forensic psychology. Thank you.
All right, without objection, and pursuant to Rule 702 of the Colorado Rules of Evidence and the decision in People versus Schreck, which is published at 22 Pacific 3rd, 68, Colorado, 2001, the court qualifies Dr. Mancuso as an expert witness in the fields of clinical neuropsychology and forensic psychology. And what that means, members of the jury, is that she's now allowed to render expert opinions in those fields. I remind you that you're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. Mr. King, you may proceed.
Thank you, Your Honor. Ma'am, what is the purpose of, first of all, I have used a couple of times the word instrument with you. Does that mean like a trombone or something, or Does that have a specific term of art meaning when we're talking about neuropsychology?
In the context of neuropsychology, that typically refers to one of our tests that's given.
Okay. And what is the purpose of administering these neuropsychological instruments? What can they tell us?
They can tell us, excuse me, how someone, are there cognitive abilities within normal limits, or are there deficiencies? And sometimes the neuropsychological testing can also be used to assist in determining whether there is underlying brain dysfunction.
Okay. And could that brain dysfunction come from any number of sources? For example, could that brain dysfunction or cognitive disability come from having a head injury versus having a psychiatric condition like schizophrenia versus having a personality disorder?
Right. The deficits, if they are present, could come from any number of sources.
Okay. And so when you administer these neuropsychological instruments, are they going to tell you, for example, what the diagnosis of the patient is?
No.
Are they going to, might they be consistent or inconsistent with a particular diagnosis, for example?
One could say that, yes.
Now, let's talk a little bit about the scope of the work that you do and the scope of the work that you specifically did in this case. As a forensic psychologist and a clinical neuropsychologist, are you qualified to do a full-blown forensic sanity examination of a defendant?
Per recent change in Colorado law, yes, I would be.
And is that what you did in this case?
No, not at all.
And is that uncommon for you to not always do a full-blown forensic examination of a defendant?
Yes, it's very common in my work as a neuropsychologist to be consulted specifically to do neuropsychological testing when a psychiatrist, or in some cases another psychologist, is conducting the sanity evaluation.
Understood. And in this specific case, who contacted you and what were you asked to do?
I was contacted by Dr. Gray, who had been contacted by Dr. Metzner, who was assigned to complete the court-ordered sanity evaluation for Mr. Holmes at CMHIP.
Okay. And what did you understand your role to be in that in Dr. Metzner's examination?
To provide a neuropsychological evaluation to assist Dr. Metzner in understanding whether Mr. Holmes had any deficits in his neuropsychological functioning.
Okay. So have you in the past, or are you now here to opine about Mr. Holmes' sanity, for example?
I am not.
Are you here to give a definitive opinion about what you think the diagnosis Mr. Holmes suffers from is?
I am not.
Did you review all of the materials in the case, including 24 hours of videotaped examination by Dr. Reed?
I did not.
Is it necessary for you to do that in order to perform the limited function that you performed, meaning administering the neuropsychological testing instruments?
It is not.
Why is that?
Well, my goal and my job was to conduct testing, provide Dr. Metzner with the results of those testing, with the results of the testing, not to offer a larger opinion about what that might mean in terms of Mr. Holmes' sanity. That was Dr. Metzner's job.
Okay. In a little while, I want to talk to you a little bit about your interactions with Mr. Holmes. Is that all right?
Of course.
But before I do that, I just want to ask you, did you interact with him personally, and is that important in conducting the limited type of examination that you did?
Yes, I interacted with him personally for 6 hours and 15 minutes,
Okay.
and that is important in order to administer the tests. They have to be done face-to-face.
And we've heard from various psychiatrists at this point in time who do this thing apparently called a clinical interview, where they sit and they talk with the person and ask questions. Did you do something like that?
We did.
And why?
It was a brief clinical interview, not meant to be comprehensive nor to address questions of sanity, but it was conducted in order to provide a context for our testing results.
Okay. Is it important that you know some basic information about the person's past and history, for example?
Of course, yes.
Would it be important for you to know whether the person was on medication or not?
Yes.
Would it be important to know when you administered the test whether the person had had enough to eat or sleep, or whether they were physically ill somehow?
Of course, all those things are important.
Now, what limitations were placed on you, or did you place on yourself, in terms of conducting that clinical interview with Mr. Holmes? In other words, did you talk about everything you could think of, or what did you refrain from talking about?
No, we did not talk about everything we could think of because that was beyond our role here. For example, we did not focus with Mr. Holmes an interview on his mental state immediately prior to or at the time of the shootings. That was beyond our scope. We focused on his general background, medical, mental health, educational, vocational history, and then his more recent status, for example, at Denver Health before he, in 2012, and then his current status.
Okay. What information were you provided prior to conducting your clinical interview and your testing?
I was provided with, and may I refer to my report to refresh my memory or not, or don't you want me to?
Absolutely.
Okay.
If you need to refresh your memory at any time, just feel free to do that. Just let us know when you need to do that and what you're looking at if you can.
Of course.
I have no objection to that, Your Honor.
Okay.
Thank you. So we were provided with previous mental health records for Mr. Holmes, and I'm referring to page 2 of my report, from the Family Service Agency of Monterey Peninsula from 1996, or January to April of 1996. We had some limited records from an agency called Psych Care pertaining to therapy sessions in 2001 and 2002. We had records from Action Care Ambulance from 11/13 of 2012 to 11/15/2012. We had, and this, when I say we, I'm referring to myself and Dr. Thomas Gray.
Let's talk about that for 1 second.
Okay, sure.
Because you keep saying we. Dr. Thomas Gray is who?
Dr. Thomas Gray is a board-certified forensic psychologist who conducted psychological testing in conjunction with my neuropsychological testing.
Was that also at the request of Dr. Metzner?
That is correct.
And did you conduct the clinical interview we just talked about with Dr. Gray? In other words, were the two of you interviewing Mr. Holmes at the same time?
That portion of the examination, yes, we were.
Okay. Did you do your testing at the same time?
No.
Okay, you did your testing separately from
I did all my neuropsychological testing with just Mr. Holmes and me.
Okay. I think the last item that you said that you reviewed were the records from Action Care Ambulance. What else did you review prior to administering these instruments?
Mr. Holmes's journal, also referred to as the notebook.
Okay, wait one moment. Did you explore with Mr. Holmes all of the writings in the notebook?
No, we did not.
Did you ask him what he meant by the things that he wrote in the notebook?
No, we did not.
Any of them?
No, we didn't. That was beyond the scope of our work.
Okay. And did you deliberately avoid doing that?
We did.
What else did you review other than the contents of the notebook?
We reviewed records from Denver Health from November 2012, and then also medical and mental health records from the jail, Arapahoe County Detention Facility, and we had them from July of 2012 through May of 2013. We had medical and mental health records from the University of Colorado Student Health Services from March through June of 2012. We had a transcript of the preliminary hearing that took place in January 2013. I reviewed a neuropsychological evaluation authored by Robert Hanlon, a neuropsychiatric evaluation authored by Raquel Gurr, and then we had some information from Dr. Metzner as well.
Okay. Subsequent to doing your examination and issuing your report, have you been provided with additional information, like Dr. Metzner's report, for example?
Yes, I have that whole report, and I've been provided with other reports, additional information.
Have you read Dr. Reed's report, for example?
I have.
And to other follow-up reports from other doctors?
Correct.
Okay. Have you received or reviewed any other records that you can think of, other than the ones you've listed?
You mean other than, we've talked about generally other follow-up reports that you didn't mention? Yes, I've looked at additional follow-ups, but in terms of what's in my report and as well as the information from Dr. Metzner, that's it.
Okay. Who decided what tests you were going to administer to Mr. Holmes? Did Dr. Metzner or Dr. Gray call you up and say, look, you need to do this one and this one and this one?
No, I decided which tests I would administer.
And how do you go about making that decision?
Well, generally, as a neuropsychologist conducting this type of evaluation, one wants a reasonably thorough picture of all the primary aspects of cognition or thinking. So I chose tests that touched on all those realms. And in this case, some of my decisions were modified by previous testing that Mr. Holmes had undergone in April of 2013.
How was it modified by that?
Well, he'd had IQ testing and formal memory testing with Dr. Hanlon, and I chose not to re-administer IQ tests quite so soon. It was like, April to August. There would be what we call practice effects that would have clouded my findings. People kind of learn how to do these tests, and they get better at them just because they've practiced. And I would have had concerns about my results on some of those tests.
So are there kind of rules and guidelines about how soon you can re-administer a given test and how you need to deal with that practice effect?
Well, the American Academy of Clinical Neuropsychology has published a document regarding practice effects, and there are not hard and fast rules. And in fact, I did choose to re-administer certain tests that Dr. Hanlon had given. It's a call by the individual neuropsychologist, but the important point is to be cognizant of that potential for an increase in score due to those practice effects if you're going to do it.
Okay. Since you mentioned the intelligence testing and the other psychological testing that Dr. Hanlon had already done, have you had a chance to review Dr. Hanlon's work that he did on that testing?
I did. I reviewed the raw data and the report.
And did you have any disagreement with the way that he administered those tests or the results of the tests?
I had no disagreement with his reporting of the results of the tests or his scoring. I certainly wasn't there to watch him administer them, but I would assume they were administered properly. He's a board-certified professional.
Okay. And is that why you decided part of the reason why you decided you didn't need to do it again?
Well, part of it also, I wanted to administer some other tests that touched on the same domains. So, for example, I administered other tests of language that Dr. Hanlon did, just to see, I'm looking at consistency in performance. Is he performing about the same? Is he declining, or is he improving? If we're doing this same domain, like memory, visual spatial processing, but using different tests, I'm interested in that.
So different ways to run at the same issue, kind of.
Basically.
You just talked about domains. What are domains?
Right. So when I refer to that, it's all I'm referring to is different aspects of cognition, like memory, attention, problem solving, visual spatial functions, that sort of thing.
So are there different tests that relate to different domains then?
Yes, there are.
How many tests did you give? Do you remember?
I'd have to go back and count. I gave him quite a few. Did you want me to count them and add them up for you, or did you just...
Let me see. I can count.
Okay, I'll defer to you then.
$20 of them?
That would be approximately right, although I didn't double check your counting. I'm going to assume you counted them.
And is the number of them important or?
Well, it's not like, again, there's not a hard and fast rule on I gave 18 and he gave 20. It's basically, did you do an adequate assessment in each of the relevant domains of thinking that you're trying to examine? In other words, I wasn't just going to give Mr. Holmes 1 or 2 tests here and come to court and tell you I was done. If I had an evaluation like this, I was going to try to do a thorough job.
Great. And what domains were you looking at specifically?
Well, I was looking at, first of all, the domain which I haven't mentioned so far is the domain of validity, right?
Let's talk about that first.
All right. So when you conduct these kinds of tests, and it may have occurred, to anybody here who is listening to talk about testing in the context of a criminal forensic case, the first question that comes to mind across the board in every case that has to be answered is the person faking? Are they feigning or malingering mental disease or defect in order to achieve a desired legal goal? So that has to be answered. So we have tests that we use that help us determine whether someone is feigning or faking problems in their thinking.
Okay. And are these tests validated somehow prior to you using them? I mean, where do they come up with these tests?
Sure, where do they come up with these tests? They're validated typically in two different ways. So there's a lot of research that gets done on them before they're put into practice. They're validated in one way, what we call unknown groups, like we have people who, it's a research study where one group of people is being instructed to fake problems and another group of people is instructed to answer the tests accurately, and often they're being paid in order to, both sides, in order to facilitate motivation to do their job right, in other words, take the test properly or fake, and then differences are looked at. And it's also, these tests are validated on clinical samples, so there might be a group of people who, like a team of psychiatrists has determined is feigning or faking, and then a group of people that a team of psychiatrists or psychologists has determined is not. And then you see how they perform on this test, and you get cutoff scores for different types of feigning or faking.
That almost sounds like there's like an objective measure of the tests, or that it's an objective way of comparing the test results against other individuals in a population. Is that the way it works?
Sure, there are a number of these tests. You end up with objective scores that allow you to make a call on, and there's no one test that's going to answer that. That's why we do several as a rule.
Okay.
Okay.
What kind of validity testing did you do with Mr. Holmes?
Yes, I did several. I did the test of memory malingering. It's often called the TOM, and that's a test to determine whether someone is feigning or faking memory problems for new information.
And how did he respond on the TOM?
He performed normally with no evidence of feigning or faking.
Okay. Now, are these infallible, these tests? Is it
No.
absolutely impossible to beat the test?
No test is infallible, of course not. And tests always must be looked at in the context of other test results as well as a clinical examination. So yeah, no test is infallible, and certainly one would never hang your hat on the results of one test in terms of any of these interpretations.
Is that why it's a good idea to do a number of different tests and to do them perhaps at different times?
Absolutely.
Any other validity testing that you did?
Yes, I did. I administered a test called the Validity Indicator Profile, shortened for VIP, and that assesses whether someone is feigning or faking problems with reasoning and problem solving for both words and visual material.
Okay. And how did Mr. Holmes perform on that test?
He performed in the valid, compliant range with no evidence of feigning or faking.
Any other validity testing that you did?
I did the B test, which is another test of whether someone is faking cognitive problems, and he performed in the normal effort range.
So you're talking about faking symptoms of mental illness as well as not trying very hard on the test?
No, this would be, the mental illness piece I will leave to Dr. Gray.
Okay.
This would be feigning or faking cognitive problems, like pretending I can't think straight in terms of solving a basic problem, when in fact I can, or pretending or faking that I can't remember what you've just told me, when in fact I can. So it's thinking skills as opposed to psychotic symptoms.
Any indication, any other validity testing that you did?
Those were the tests that I administered.
And what were the conclusions, if any, that you drew from this validity testing that you did about Mr. Holmes' effort and potential faking in the course of this testing?
And my test results, in conjunction with my clinical interview, led me to the conclusion that his effort and cooperation were adequate during testing.
And why do you incorporate the clinical interview in that opinion, ma'am?
Well, I always look at behavior observations. Of course, no clinician is infallible. No psychologist or psychiatrist can always see through people. But, having done many, many evaluations of, certainly a lot of them in the criminal forensic realm, you see a lot of people who do feign, and they fake symptoms and problems and deficits they don't have. So I need to be on the lookout, if you will, for those kinds of behaviors in order to supplement the test results.
Sounds like you really keep your eye open for this stuff.
I always do. It's part of my job.
In your expert opinion, then, is there any reason that this jury or anyone else should be concerned about whether Mr. Holmes was putting forth a good effort or faking in this context?
In this context, not at all, no.
What's a normative reference base?
So when you have test results like that pertain to thinking skills, someone produces a score, okay? More often than not, we don't necessarily have a score that came before it. So in other words, we don't know if this score represents a deficit for them, a new problem. So and most of the time we don't have that pre-existing testing. So what we have to do is to compare someone's score to the population that they are a part of to determine whether that is similar to what others in their demographic group should be getting, or is it worse?
Okay. So, and I'm not very good at this, but so correct me if I'm wrong, if I'm getting this wrong, but it sounds like you're saying best to compare him against himself at a previous time, but second best to compare him against a population, a statistical population of people like him.
That would be true.
Okay. Would this be similar to like in DNA testing, they compare the test against, white males in North America or something like that? What do the groups look like?
Yeah, what do the groups look like? Right. And so we're looking, of course, at specific factors in terms of the group itself.
Okay. What kind of factors?
Typically, we're as many of demographic factors as we can get. In many of the tests I administered, we have age, education is very important, and then gender, which is important when we do motor testing, and then ethnicity is important if you have norms that correct for that.
Are all of these things taken into consideration then when you score up the tests and get results?
Right. Not all the tests have all of those normative pieces covered, but the normative factors are definitely taken into account. For example, you wouldn't expect the same kind of memory performance out of an 85-year-old woman as you would a 21-year-old woman, that sort of thing.
Understood. Sometimes your tests have like scores on them that seem to be between like 1 and 100 or something like that. Where does that come from, and what should we derive from those scores? Are they called T-scores?
Right. There are different summary scores that we use to describe the test result, and those kinds of scores that you referenced refer back to how the person is comparing to their normative group. One of them is a T-score that has an average of 50, a mean of 50, and a standard deviation of 10.
Okay. Judge, do we want to break for lunch now, or?
I was hoping to keep going for a while since we started late. So why don't we keep going? We're planning on taking a short lunch break, if it's all right with you.
Fine with me, whatever the court prefers.
Yeah, let's just keep going for a while.
Let's talk a little bit about another domain then. Let's talk about attention and processing speed.
Yes.
What's that?
So that is a person's ability to focus their attention and concentrate on a task, and also how quickly and accurately can they process information. And we have several tests that we use and that I used to assess for that.
What test did you use?
I used the trail making test part A.
Trail making?
Trail making test, yes. I used the digit vigilance test, and you get 2 scores for accuracy and speed. I used, may I refer to my report? I want to respond accurately here.
That's fine.
Okay.
Is there like a silly names contest for these tests, or?
No, there's not that I know of, but maybe you'll start one up. And then I used of course, the speech sounds perception test and the seashore rhythm test.
Before we get into this, let's talk a little bit about some of these different tests and how you actually administer them to the person.
All right.
Okay? Can we pick one of these and have you describe how it's administered, please?
Sure. Why don't I can start with the digit vigilance test, since that is what I mentioned first in my report.
Yeah, what does that look like when you're
doing it?
So
it's 2-sheet. It's a number cancellation test where the person is instructed to cross off as quickly as they can a certain number. And they have to do it quickly and accurately. It's kind of tedious, if you will, right? It's not an interesting task. So we're looking for speed and accuracy. And those are the 2 scores that are obtained. You're timing them.
So it's a timed test.
Correct.
And you're looking for a number, and then you have to cross it out.
They have to cross it out.
And so what you're testing for is their attention and
Right,
their ability to... Go ahead.
Yeah, and their visual processing, because it's a visual task. They're looking at it and having to pay attention and process the numbers that they're seeing.
And are these all different aspects of our cognition, the way that we think?
Right, that is one aspect. That represents one aspect.
What other tests did you give in this? What was the other one you mentioned?
For example, I did, like I said, several of them.
Speech sounds perception test.
Speech sounds perception test. So he's listening to an audio recorded version of what we would call nonsense words. They're not real words, but they're sounds. And then he has to look on a sheet of paper and match those words to a phonetic representation, in other words, the printed version, and he has to choose the correct answer from a series of four, three of which are wrong. And there's, a number of many items of that variety.
And you said the trail making test, and then was there a seashore rhythm test?
Both of those.
Okay.
So-
And what's the seashore rhythm test?
So that is also an audio recorded test where it's a nonverbal auditory attention test. So it's, in other words, they're listening, it's auditory, but it's not words. They're listening to different beeps, if you will. It's a pattern of beeps that they have to listen to. They increase in length and complexity, and they have to determine whether the two patterns they hear are the same or different.
Okay. How did Mr. Holmes perform on these various tests? The test of attention and processing speed.
In all but one, he performed within normal limits, or I think above in one area. Well, within the average range on all but one.
Okay, and which was the one that he was outside the average range?
He was basically just below average on the seashore rhythm test.
Okay. Does that have any special significance?
Well, just overall, it had significance to me that his attention and processing speed was basically pretty good. Wasn't severely impaired. The one that was out of range, I took note of it, but I didn't overinterpret it because it was one score.
Would the test have shown if he had an extraordinary degree of attention or processing speed?
No, not extraordinary, but I would say that all these scores that I've just told you about, where he's scoring in the average range, that would be the average range for men in his age range with his advanced level of education. So that's a pretty high standard, right? I'm not comparing him to, 84-year-old men who've only gone through the 5th grade. He's being compared with highly educated young men in his age range.
So you're comparing him with young men in his age range that have what degree of education?
I think it's 16 to 17 years is the age range that he was compared against. Or excuse me, the education range he was compared against.
So that's like 12 years of...
high school, 4 years of college, and then about a year or so after that.
Of graduate school.
That's correct.
It's interesting, and so you can really narrow the field that much, huh?
Right. Well, it's all in how they're normed. That's why these tests are they're difficult to develop, because a good test is properly normed, and it takes a long time to do that.
A long time to develop that population to norm it against?
Well, or for people to go out and actually get the data,
Okay. Let's talk about another domain called language. What did you do with language?
So I assessed both his receptive language abilities and his expressive language abilities. Receptive meaning how well can he understand what he hears, and expressive meaning how well can he produce sounds and words and make himself understood.
I'm just going to, for the sake of expediency here, the Boston Diagnostic Aphasia Examination.
Yes.
How did you do on that?
He was below average, again, not severely impaired by any means, but about little less than a standard deviation below the norm for his age range and his educational and age, education, gender, and ethnicity norm group.
Okay. Looks like the Boston naming test. Did he do okay on that one?
He did very well on that. That's his ability to look at pictures and accurately come up with the names of these pictures.
Overall, how did he do in this domain of language?
Overall, I found his language abilities to be relatively intact. He scored well below average on one test, but when I looked at his errors on that test, they were errors that reflected kind of variable attention and focus at that point, as opposed to a true language deficit. I did not regard him as language impaired.
Okay. Now, what in the intelligence testing that you noticed from that Dr. Woodcock did, that Dr. Hanlon did, what was Mr. Holmes? Was he a smart guy?
Yes, he's a very, very intelligent person. Did you want to know his IQ, or did you?
Sure.
Okay, so his full-scale IQ was, when Dr. Hanlon tested him, was 123, I believe.
Okay. Does that mean he's a genius?
No, that's what we call, as psychologists, we call that superior intellect.
Okay. When you do these various domains, do you then at the end combine them for an overall picture, or do they remain separate in the way that you perceive this testing?
All of my testing, and of course we just talked about a couple domains, I look at all the tests in each domain, render an opinion about whether the domain is impaired or not, does he have language problems, etc., and then I come up with a summary opinion overall regarding his neuropsychological functioning.
Okay.
So I integrate the results.
Spatial skills. Well, what test did you give for that?
Yes, and so now I'm on page 7 of my report, and I administered the spatial relations rating, which is he has to draw a Greek cross, and then there's a time score on a test that I gave called the tactual performance test.
And how did you do with spatial skills overall?
His spatial relations rating, in other words, his drawing ability was good. It was just fine, well within normal limits for his norm group. His score on the tactual performance test was in the mildly impaired range, and I mean mildly.
Okay. And you said on a couple of these tests in different domains that he scored in the mildly impaired range or in the impaired range. How can someone who has a superior intellect somehow be below average in one or more of these domains or tests?
Right, and that's a good question. So IQ, if we're talking about IQ score as representative of intellect in the way that it's often discussed in the popular press, that doesn't assess all aspects of neurobehavioral functioning, okay? So a person might have a specific deficit in spatial processing that doesn't necessarily impede their IQ score. So I guess the take-home message is an IQ score, a full-scale IQ score is not the end-all and be-all in terms of what to attend to about someone's intellectual abilities. It's one summary score that does not include all aspects of cognition.
Thank you. Memory testing, is that another domain?
I did, yes.
And what instruments did you administer there?
I administered the story memory test, the figure memory test, and then there are also memory components of the tactual performance test.
How did Mr. Holmes do overall in terms of performance on those instruments?
They were slightly varied. On verbal memory, he was in the mildly impaired range in terms of his ability to learn new verbal information. And this is like paragraph length material, okay, so a story, mildly impaired. But he had good recall after. So in other words, he was a little slower than he should have been with his age and educational attainment to learn complex verbal material. But what he did learn, he recalled just fine. His visual memory was good. His visual his figure memory scores were quite good, above average, even for his norm group. And then on the tactual performance test, which his ability to remember information that it's basically a puzzle board, and he's not allowed to see it. He has to work with it blindfolded. He's working with these blocks with his hands, and how well can he remember that when he on the recall trial, and he had impaired scores there.
You actually put a blindfold on him?
He had a blindfold on him. It's the way this test is administered.
What is executive functions?
So executive functions, in humans, this is generally considered to be our highest level of intellectual processing and ability to reason, to think, to plan ahead, to inhibit inappropriate responses, to problem solve, those sorts of things.
Why is it the highest level?
Well, I think that's what differentiates us from many other primates, if you will. They've been shown, for example, chimpanzees can learn language, but certainly our level of processing and problem solving in terms of executive functions would exceed all other beings, if you will.
What do you know? What parts of the brain control executive functioning?
Typically, the frontal lobe is considered to, and specifically as portions of the prefrontal cortex are considered to be important in that.
Is that as the brain develops when you're growing up, is that the last part of the brain that develops?
Yes. Yes.
Is that why teenagers sometimes can do things that don't make a lot of sense, even though they might be smart?
That is what is hypothesized, yes.
What instruments did you administer to test Mr. Holmes' executive functions?
I administered what's called the trail making test Part B, and it's a paper and pencil test where he has to switch back and forth between letters and numbers and keep them in proper sequence, and he's timed. Okay. I administered the Wisconsin card sorting test. That is a test, both the trail making test and the Wisconsin card sorting test were administered by Dr. Hamlin in April, so he'd had exposure to both of those. But I administered that. That's a measure of problem solving, cognitive flexibility. He has to solve a certain series of problems with minimal information from me about how to go about it. All he gets is feedback if he's right or wrong, and then he has to keep adapting his problem-solving strategy based on my feedback, which is very specific to the test instructions. And then I also administered the booklet category test, which is he's looking at a series of designs and having to reason abstractly about those designs. And I also administered the Thurstone word fluency test, which is sometimes considered a language test, but it also assesses executive functions. Basically, fluency of thought. How quickly can he come up with a certain series of words that I ask him to in various categories?
When you're administering these tests, especially when I'm thinking about it in terms of this executive functioning, when you administered these tests, did you do it all at one time, or is it important to space them out temporarily? Some of them seem like they would be kind of hard, and I'm wondering if is fatigue a factor, or?
Fatigue certainly can be a factor, and yes, they were spaced out over different sessions. They weren't all administered in one clump.
Is it significant whether or not a person might be medicated at the time that they take these tests with like a antipsychotic medication, for example?
That can certainly be significant.
Was Mr. Holmes taking Risperdal at the time that you conducted the test?
Yes.
What date did you do this testing? Do you remember?
Well, you mean this executive functioning testing or all the testing?
How about all the testing?
All the testing. I started on August 12th, 2013, and I saw him on the 12th, the 13th, and the 14th, and that was the end of his testing with me.
Okay.
Okay.
And was the testing kind of interspersed with his interviews with Dr. Metzner and contact with Dr. Gray at the same time, or do you not know?
I remember with Dr. Gray, surely, because Dr. Gray was doing his testing with Mr. Holmes at different sessions than me, and it was that same interval. I can't recall if Dr. Metzner did all his sessions. I know he spaced them out as well, but I don't recall where they fell in relation to those days, if he was evaluating Mr. Holmes the same days. I think not, but I can't recall.
Okay, but it took place over a series of days.
Yes, that's correct.
Down in Pueblo at the hospital.
That's right.
How did he do on the various executive functioning tests? Did you mention the Thurstone word fluency test? Yes, you did.
I did.
How about the booklet category test?
I did.
How did he do on those?
He did well on all those tests. He performed well. I want to look at my report so I can make sure I'm answering you accurately.
Yes, ma'am.
Yes, he performed within normal limits for his demographic group, in other words, men in his educational range, individuals in his educational range and his age range on all these tests.
Okay. And then it looks like it was the last domain, sensory motor testing?
Yes.
What's sensory-motor testing?
Okay, so this is a domain of neuropsychological functioning that is not always included. It doesn't have to be included in an assessment, but I was trained to include it, so I often do. And what this is, it lets us look at people's motor function, so it's exactly what it sounds like, their hand functioning, with various tests of fine finger dexterity, grip strength sometimes, and so forth. I did fine finger dexterity and tapping speed.
What is finger dexterity?
Oh, sorry, yes. So, of course, that test, what I'm referring to, is called the grooved pegboard test. It's a metal test about this big. It has holes and that are in different shapes, and there are different configurations, and the person has to put the pegs in the holes as quickly as he can. He's timed. And so people who have motor impairments of various kinds are slower to do that. And basically, we're looking at right-left differences. Are there differences from one side or the other?
That was going to be my next
Oh, I'm
question.
sorry, I shouldn't have
Which
asked.
is, yeah, you're stealing my question.
I'm sorry.
What's the significance of how fast someone can tap their fingers, or what their grip strength is to their cognition?
Well, everything has to be interpreted in context, of course. Now, someone who has a traumatic brain injury, and it's a known traumatic brain injury, and their scores on their motor functions are impaired, and there's no other explanation, you might say it's consistent with that. But some people who don't have other reasonable explanations for motor impairment, like no spinal cord injury, no other motor impairment from previous injuries, and no medication issues that might be affecting their motor scores, then you would raise a question as to whether it is affecting a portion of their brain called the motor cortex. It's in the frontal lobe. You can question whether that is affected.
Okay. Now, were the results, were those all the tests that you gave? Did we go through them all, do you think?
Right, except for sensory perceptual testing.
What was that? Tell me about that.
So basically, you are, again, it's a right-left difference I'm looking for. You give a person visual stimuli in both the right side, the left side, and both sides, and you do the same thing with touching. I had to touch his cheek, I had to touch his hands, right side, left side, both sides, and then auditory. You're doing a finger click in either ear. So it's a clinical assessment, obviously, and we want to know whether someone is able to respond accurately to the right and the left, but when both stimuli are presented together, are they ignoring one side or the other? And that has implications for certain kinds of brain disorders.
Okay. Overall, were the results of your neuropsychological testing largely consistent or inconsistent with the neuropsychological testing that Dr. Hanlon did in April of 2013?
Overall, they were largely consistent.
Did your profile yield any evidence of subtle neuropsychological dysfunction relative to what was expected in Mr. Holmes?
It did. Subtle neuropsychological dysfunction.
And what domains were those in, again, if you can recall?
Of course. It would be verbal learning, okay, and it would be in tactile motor problem solving. That was the TPT test, and spatial recall.
Okay.
Okay.
Would it be fair to say that overall a large majority of his scores are within normal limits?
Yes.
Would it be fair to say that those scores that are within normal limits are not reflective of any impairment in his ability to pay attention, reason, use language, remember, or problem solve?
Yes.
You mentioned the antipsychotic medication that he was on. How might that affect the testing?
Well, it could affect it in different ways. Now, if he was over-medicated, like taking a very high dose, because I work at a hospital where people are, not Mr. Holmes, but some people are on very, very high doses of medication, are they experiencing a delirium secondary to their medication? So that could affect their ability to even pay attention in testing, right, and focus on what I need. Other times, if someone has a psychosis, and they are then prescribed an antipsychotic medication, that can improve their ability to attend and focus and pay attention during a test session. So in that realm, it could improve their cognition.
Is it very possible then that his neuropsychological functioning would be differentially worse if he was experiencing active psychotic symptoms that were not controlled by medication?
Yes.
Is that likely to be the case?
I don't know.
Judge, is this a good time to break, or?
Yes, do you still have a ways to go?
I have probably about 20 minutes, 15 minutes, or 20 minutes to go.
All right, we'll go ahead and take our lunch break at this time. Would counsel approach for just a moment, please? I had indicated yesterday that we would probably take a short lunch break, but I've decided we should take the usual hour and a half instead, okay? We're still ahead of schedule, so I'm happy about that. And we can take an hour an hour and a half, and so let's take an hour and a half. Please make sure that you follow all my admonishments during the lunch break, but enjoy the lunch, and I'll see you back here in an hour and a half. Thank you. Please be seated, everyone. The record should reflect the jury has exited the courtroom. Unless there's something we need to talk about, I suggest we go on break, and then we meet back here in an hour and a half, which I think would be at 1:55, okay? All right, the court will be in recess. Thank you.